I think if you had to like do a subtitle to this case, it would be called "An Ounce of Prevention is Worth a Pound of Cure." I think I'll keep this here just in case I have to read out.
What's going wrong?
I'm gonna go back to the restroom. What time is it now?
I believe it's 1:50.
Okay.
If you want, I can throw those away. We've got a trash can right here.
Okay. Yeah, not needed again. Amazing how fast you can type on those things.
She can.
Thank you.
I need nails to kind of give me a point.
Yeah, thanks.
Jeff, do you want to ask you a couple of questions?
Yeah.
Do you happen to have the transcripts from all the predecessor cases that were referenced in the Mojave County cases?
I do not. I didn't.
Okay.
I never got any of those with, because it was, the original. You're talking about the 363 and the 5A?
Yeah, yeah. Those particular cases. The reason I'm asking is because when I was looking at the, I got this order kind of disconcerting to me because you don't have to wait that quick and I get an order that asks the questions and you answer it. I originally wrote yes too. And then I started thinking that these prior cases from Mojave County, one of them had 3 counts.
Right.
And the question then, well, if the court could conceivably say, well, if they occurred on separate occasions, you would have 4 errors on the priors.
True, and I think that Judge Jansen in his sentencing comments said something about making there could be an argument that there could be more than one from that case, but then he.
Then he delved into it because it's finding each of them.
But if he needed to, he should have delved into it.
Right, right.
But the prosecutor didn't even argue it, so.
Right.
Um,
The reason I just bring it up because I do have those transcripts because our office.
Because your office did the appeal on the first one?
Right, and the reason why I asked is because I don't want, obviously you're not gonna know anything about this, and the question might be, is I'm gonna answer the question saying the easiest way to deal with this is to deal with the California priors. But if there were another way, it would be, forgetting about the priors and just looking at the Mojave County ones, because there are 4 convictions. Of course, the court would have to find them committed on separate occasions. So I wanted to let you know, that's why the reason why I asked you that question. If you're not able to answer that question, I think it's not really fair for me, I don't want the court to have to go into that with you not having had the record to read it. And I just happened to look at it
Jill Evans from the Public Defender's Office handled it originally.
Right.
Well, I don't know if she handled the appeals on the 363 and the 58 cases or not.
She definitely did do the
But
5A case.
But she did the appeal on this one, and it's, and then, you know, after that was done, it got reassigned to Ms. Van Brewer for purposes of sentencing.
Right.
Obviously, I think that he conceded incorrectly
I think you and I can
That-
have a
that-
lot to agree upon.
that,
That's also done here.
you know, that that two Arizona cases are priors under Thomas.
Right.
They're not priors without.
No, they're not prior, I mean, well,
Well,
I think they'll be coming in pretty soon. Are they on their way in?
Soon, are you both ready?
I think I want to get it over with. I'll answer yes.
You'll answer yes, how about
Answer
you,
yes.
sir?
I think I'm as ready as I'm going to be,
Okay.
which is yes.
All right. We're about to start. Everyone could put their electronic devices on silent.
Thank you. Please be seated. Good afternoon. This is the time set for oral argument in State versus Leroy Montoya. Counsel, we are making an unofficial record of today's proceeding by both audio and video recording. So when you step to the podium, if you would, please state your name and identify the party you represent. Each party will have 20 minutes for argument, and appellant's counsel is responsible for watching the clock and reserving any time for rebuttal that you might desire. We've read the briefs, we've conferenced the case. As you know, we sent out an order telling you of some topics that interest us, and in conferencing the case, I'll tell you that I think we can understand from the record how the Superior Court found one historical prior felony conviction based on one California conviction and one from each of the two Mojave criminal cases. We're a little bit stymied about how the court got to the second historical prior. So to the extent you can help us with that, we would appreciate it. And with those preliminaries, Mr. James, you may proceed.
Thank you. If it please the court. Jeff James, attorney for Leroy Montoya. In addressing the questions that the court sent out setting oral argument with respect to whether or not the Superior Court needed to rely on both California convictions to sentence Mr. Montoya with two historical priors, it's our position that the answer for that would be yes. And the answer for it being yes is that the two Arizona convictions, the court treated the convictions from CR 2007-363 and CR 2007-0058, Mr. Montoya's other two cases, as historical prior felony convictions, I believe on the basis that Mr. Brewer, Mr. Montoya's sentencing counsel, incorrectly Montoya, in this case, CR 2007-0095, I'll go by the Mojave County case numbers. The court found that that offense was committed on or between September 1st of 2006 and November 1st of 2006. With respect to the convictions in CR 2007-363, the theft conviction was committed on or about October 18th of 2006, so there's nothing in the record that would establish that that would actually be an offense that was committed within the 5 years immediately prior to the conviction.
And if there's overlap of dates, what legal effect does that have? Because as I'm looking at it, the current offense was between 9/106 and 11/106, and the offense you're talking about, the theft from 363, was October of 06, which would fall within the time span of the current offense. Does that matter?
Judge, I think it does matter, and I think it's incumbent upon the state to present proof. If the state's going to rely on that being a historical prior on the basis that it's a class 4, 5, or 6 felony committed within 5 years immediately prior to the date of the offense, it's incumbent upon the state to present proof of that, and the state and the record's devoid of that. And in that situation, Mr. Montoya should be given the benefit of doubt.
What about the 363 fraudulent schemes and artifices as a class 2 under, now I've forgotten whether it's B or C?
I believe that that's B, Your Honor.
Is that?
The same argument would apply again, because there's dates that could have been committed that are prior to, well, looking at the fraud scheme date, it starts on October 1st of 2006. That's a date that could have, where the Mojave County, the CR95 charge could have been committed between the dates of October 1st and the 18th. And again, it puts it in a situation where it's not something that was committed prior. So,
well, let me ask you this, and I actually have a question for Mr. Walsh. On the flip side, are you sort of stuck with what trial counsel did? Trial counsel seemed to concede that there could be something arising from 363 that gave one prior. Similarly, the state in the trial court argued that there was no evidence that California offenses were separate. There was no evidence that the grand theft would have been a felony in Arizona. I mean, what should we make of those?
Well, Your Honor, I don't believe that the court, the trial court can, I think the trial court's application of a prior felony that is incorrect is fundamental error, and I don't think that Mr. Montoya is bound by Mr. Brewer's mistakes. I don't think that that's a waiver argument, or if it is a waiver, this court should review it for fundamental error, and it's our position that that would be fundamental error. Going to the CR 2007-0058 felony convictions, again, those are all convictions that have dates that potentially fall, well, the criminal damage offense definitely falls after the trafficking, because the criminal damage offense is December 1st through January 2nd, 2007. So that one cannot be a historical prior on the basis of what was 13604W2B with respect to the fraudulent scheme conviction and the participating in criminal street gang offenses. And the fraudulent scheme, again, has an overlapping date, and then the participating in a criminal street gang offense is a date that by the charging is a date after the trafficking. So it can't be a historical prior under 13-604W2B or C. It would have to become a historical prior on some other basis. And what it appears happened is that the trial court, found Mr. Brewer's arguments in his sentencing memorandum to be a concession that they were historical priors under 13-604, both of them, and the court didn't look at whether or not there was a California first conviction that would be a 1, and then whether or not CR 2007-363 would be a 2, and then CR 2007-0058 would be a 3, which goes into answering the second question. If the court was correct in finding that the California conviction was a felony conviction for purposes of sentence enhancement under Arizona law, then the application of 13-604W2, and it would be D, not B or C, and Thomas, because there's no it's only the conviction has to happen first, not the date of the offense, then the application of that would result in Mr. Montoya having 1 historical prior conviction, if the court was correct in determining that the unlawful taking of vehicle in California was a felony. So
what you're saying is, if the trial court correctly found that the taking the vehicle without consent in California would be a felony in Arizona, that was 1 prior felony conviction, and then counting forward, the 058 would be the 3rd, and under D would be 1 historical prior under D.
I believe that is correct.
Okay.
Because
so was the trial court correct in finding that the taking a vehicle without an owner's consent in California was a felony in Arizona, would be a felony in Arizona?
It's our position that the trial court was not correct, because there was not anything in the record that would support the trial court making such a finding.
Like what? I mean, and I have to confess, I haven't looked at the record in the last couple of weeks. I looked at it on our prior date, but the court did do some analysis of elements, didn't it? Remind me what the court undertook and what you think it should have done that it didn't do.
The only thing that the trial court, the prosecutor didn't make any reference to any type of elements, to what it was. He just talked about the name of the offense, that it was sometime in 2000, didn't really have much other information about it. He was cavalier in discussing whether or not it was even a Class 2 and 3 versus a Class 4, 5, or 6 felony. He stated in the record that he didn't have any evidence of that. The trial court simply made reference to that it had looked at the elements of each of the statutes and that the statutes complied with one another. The trial court didn't say anything more as to what he looked at, when he looked at it, whether or not it was a version of the 2000 California Penal Code versus a 2012 version of the California Penal Code. All he did is made a reference that he looked at the statutes, and the statutes, or that the elements matched.
So it's more that you fault the court for not elaborating on the California statute, because now I found the transcript and refreshed my recollection. The court does talk about the different Arizona offenses that it might match. Unlawful use, theft of a means of transportation, possessing or being in a vehicle, joyriding. So the court did seem to focus on the Arizona statutes without mentioning them by number, but you think the court didn't adequately talk about what was the underlying California offense?
The state didn't present any evidence of what those
the
would be.
court did it for the state.
Right,
really.
and then the court made reference to things without stating anything in the record that would allow this court to review what information the court had in its place to be able to do that. So given that, it's our position that the California conviction would not be a felony for purposes of sentencing at this point in time, because the record is devoid of the information.
But you're not saying that if the court had actually gone through the analysis and is correct, then that's fine then.
Well, again, I don't know. I don't think this court, I don't think anybody knows specifically what the court looked at or what analysis the court went through. I know that this is a case that was remanded because there was a mistake the first time on how the priors were found, and I believe that Mr. Montoya in the state was entitled, well, the state should have presented the information to the court, and the court should have stated on the record how it got to the California conviction being a conviction. The court also, I believe, made a mistake in determining that the 363 and the 58 cases were historical prior felony convictions, because the court made that on an incorrect concession by the sentencing counsel, and the court should have made a record of why it was stating, well, I think the court's record of stating why it was historical priors was simply that based on the defense, Mr. Brewer's concession, that they were historicals under Thomas, that he was finding that there were two historicals. I believe the court didn't even consider the California conviction really for purposes of determining whether or not there was a historical prior under 13-604 W2D.
Yeah, I think at one time the court says it doesn't matter. The California doesn't really matter. What you're not prepared today, I take it, to march us through the possible relationships between the California taking the vehicle without consent and the possible Arizona statutes. That's not really your. I hate to have you take up your time if you're not.
No,
Okay.
I'm not prepared to tell the court what the California Penal Code said from back in 2000 or not. I haven't looked at that. I don't believe that is something that is necessary for purposes of whether or not the trial court was right or wrong in this case.
So the court's error was not in making this analysis explicit?
Well, I think the court's error has to, the trial court has to make its findings in such a manner that allows a court reviewing it to make a determination of what information that court based its information on. And in this particular instant, it's not something where you would, I believe, defer to the trial court as to credibility of witness type issues and things like that. But this is really a question, or whether or not the courts, I think the proper standard review of whether or not a prior conviction is a prior is a mixed question of fact and de novo review, and the de novo review of the facts presented.
Well, you're saying we need to know, for example, the statute.
Yes.
The statute that was violated.
Yes.
Under which the conviction was obtained.
Yes.
So we have a target to match it up against.
Yes.
Yeah.
I mean, the prosecutor relied simply on that it was the title of the offense was taking a vehicle, and if you take a vehicle in Arizona, it must be a felony. And the prosecutor didn't give the court any information as to what the California statute said as well. Now, regarding, again, so with respect to the specific questions that this court had in place for Mr. Montoya and the state, in order for the trial court to have Mr. Montoya sentenced with 2 historical priors, it's Mr. Montoya's position that the trial court would have had to found both California convictions cases were felony convictions, which would then make the other 2 cases, the 363 and the 58, they would become a 3rd and a 4th conviction, and therefore under 604 W2D, those would count as 2 historical priors. With respect to the proper application of whether or not there is one California conviction versus the 363 and the 58, it would be the position of, I believe the correct legal position would be that there would be 1 historical prior, not 2 as the court found. And at this time I will reserve the remainder of my time. Thank you.
Thank you. And Mr. Walsh.
May it please the Court, Assistant Attorney General Robert Walsh appearing on behalf of the state in this case. I'm going to answer the Court's questions that you issued in your order in reverse. I'm going to address first the question of what is the proper treatment of the Arizona convictions under ARS Section 13604W2 in State v. Thomas. Counsel and I agree that State v. Thomas was misconstrued by the trial court, the prosecutor, and the defense attorney here. The origin of that appears to have been this court's memorandum decision in the predecessor case. There was a footnote on page 21, footnote number 3, that read, while the case in which the trial court unfound the prior convictions is not before us, we note the date of conviction is the only relevant date to determine whether a prior conviction was a historical prior conviction for sentencing purposes. The date of the offense is irrelevant. It cited State v. Thomas. This was the predecessor case that led to the remand. This court subsequently did issue a amended memorandum decision where this was X'd out, but apparently it escaped notice. So I agree with counsel that Thomas was only intended to deal with subsection A, the forever priors, the 6 categories of priors, and Thomas held that subsequently committed offenses that were going to be used to enhance the present offense need not be committed before the present offense. They just had to have a conviction on it. So everyone misunderstood that, and unfortunately the reason why we're here today is because the court found the 2 Mojave County Superior Court convictions to qualify under Thomas and did so incorrectly. My position, I agree completely with counsel that subsections B and C do not apply. These, remember, the state alleged 6 prior convictions. The ones in Mojave County, obviously the October 18, 2006 commission date for the theft in CR120719 brackets the commission dates of the instant offense of trafficking stolen property. And that was September 1st of 2006 to November 1st of 2006. And we also know that the 58 case had commission dates that went from the fraudulent schemes was August 4th of 2006 to December 20th of 2006. The criminal damage was December 1st of 2006 to January 2nd of 2007. And December 6, 2006 to December 20th, 2006 for the participating in a criminal street gang. So we could see that, subsections B and C of the definition can apply. They're not forever priors. So where the state made its argument in its answering brief, consequently, was under subsection D, which basically says that any conviction that is a 3rd or more prior felony conviction. And now what the state did in its brief was it said, okay, well, how do we show that these 2 Mojave County Superior Court cases were the 3rd and 4th? And I looked at the California prior felony convictions. They were alleged by the state, these prior California convictions, the one for grand theft person in Los Angeles County Superior Court VA 059537. and unlawfully driving and taking a vehicle without the owner's consent. That was VA 061120. They were alleged by the state in this case on June 13, 2007, and they did list the statutes in that case and the dates of commission.
But doesn't the problem arise because at the resentencing, the prosecutor said to the court, I can't tell you that these were committed on different dates, nor can I even tell you that the grand theft from a person would be a felony if committed in Arizona.
Yeah, that is a problem because only 2 years earlier, that same prosecutor wound up introducing the information for both of those cases. It was on September 15th of 2010 that the state filed a response in the 58 case. Joe Evans or Eric Engen had filed on appellant's behalf a motion to modify sentence.
Well, that's why you want us to take judicial notice of the 058.
Right. And the way it came into play was that in the predecessor, this is so confusing, but in the predecessor case that we have in this one, the 95 matter, Joe Evans attached to her reply brief the minute entries from the 58 case regarding the litigation that was engendered by her motion to modify sentence. Apparently in the 58 case, the state had relied upon using an assault rifle, the California conviction that was not an Arizona conviction, and apparently we used that theft in the 363 case in the 58 case to enhance the sentence. Judge Jansen vacated his prior findings, had these two California convictions and the 363 theft, and he was dealing with, boy, I can't believe I'm keeping this straight.
Keep going, don't stop.
The 58 case with the three convictions, basically what the judge did was he found the unlawful theft California conviction to be a felony in Arizona. It would correspond to theft by control. He said that it didn't matter that the property might be under $250 because it was taken from a person, and subsection D of 13-1802D, now it's G, basically says if you take any property from a person, that's a felony. So the judge found that to be a felony in Arizona, that California prior, but said, but it's too late. It's past that 5 years, so I can't find it. But he did make a finding that the unlawful driving or taking of a vehicle with the without the owner's consent from California corresponded to our joyriding 13-1803A1 conviction, a Class 5 felony. We don't have to prove that the defendant intended to deprive the owner. That matched up with the California prior, and he then started tolling time for the defendant having been in prison for part of that time. And he found that some of the two of the three convictions that the defendant suffered in the 58 case, that they fell within the 5-year window. So basically, the prosecutor, ironically, the same prosecutor, had introduced as exhibits to his response to this motion for a modification of sentence these informations, these charging documents. What happened was the defendant in that California case pled guilty on October 18th of 2000 to both counts. And so when the prosecutor came back for a remand, he forgot about the informations. And he just looked at it and said, I'm just going to assume it was on the same date. Unfortunately, the only thing that happened on the same date in those two prior California cases was the defendant pled guilty to like a universal or global plea agreement. So when you look at those two California convictions as being non-historical convictions, they're number 1 and number 2, that would render the two Mojave County cases 3 and 4. Now, as I've indicated, the theft conviction in CR120719, that occurred on October 18th of 2006. That would be the first of the historical felony convictions in this case. And the second one, Judge Jansen said, I don't need to go into whether or not the three convictions in the 58 matter, which were the fraudulent schemes, criminal damage, and participating in a criminal street gang, whether they were committed on the same occasion or not, whether they were one conviction or three. He said, I found my prerequisite 2, and that's all I need to do. I wish he had gone further, because as I look through the record, I mean, I do want to make a statutory construction argument before I go further, but I do want to say this, that the analysis under Thomas with respect to subdivision A, basically the Arizona Supreme Court said in subdivision A, those forever priors, it doesn't matter if the defendant commits them after the present offense as long as he's convicted of them before. The court, compared the language of subsections B and C that had the language that you must commit the crime within, 5 or 10 years that it's missing. Well, the same analysis applies with D. Subsection D says any conviction that's a third or more prior felony conviction. There's no requirement that the crimes be committed before. I don't know how this court's going to resolve this issue, but you could tell from how confused everyone was below that if this court, at the minimum, could issue an opinion construing subsection D and letting the court know that Thomas's rationale applies to subsection D, even though the court erroneously applied subsection A to all these convictions, I think it would help quite a bit.
Oh, isn't the statute different now?
Well, now they redefined, they just basically took the definition of historical prior felony convictions and they put it in 13105.22. It's identically worded.
It's the same.
You know,
But I think your opposing counsel concedes the statutory analysis. We'll
Yes.
ask him when it's just, but I don't think in this room we've been assuming that that's the case,
Right.
that the problem with the two conviction, with 6.3 and 5.8 is that they cannot be, get this, now I'm losing it, I lost it.
Anything other than D?
Yeah, they have to be D, but we're assuming
Right.
that they could be D.
Yes.
If there's a first and a second.
right.
Or first, second, and third.
And right. And essentially what this court would have to do is it would have to determine that the prior California convictions would be felonies in Arizona. Now, counsel says, well, the state didn't offer any proof. Well, they did.
Back up. I mean, I think I get this, but I just want to make sure. So your answer to our question number one, did the Superior Court necessarily have to rely on two of appellant's California convictions? The answer is yes, and you're telling us why.
Well, I'm answering actually the second one, and I'm
Yeah,
saying
right.
that Thomas doesn't apply per se because it dealt with subsection A, but its analysis as applied to subsection D is sound. So I'm
Right.
saying that that's it. Now, the reason why I bring that up is that I was going, to be honest with you, until Friday of last week, I was going to say yes to the first question as well. I was going to join.
Still said that. Yeah.
Right.
But you're going to say now that one of them is a B or a C.
No, not even that.
No?
Not even that. What I'm going to say is this. In the two Mojave County Superior Court cases, let's just take them in order. In the 363 case, you have the theft that was committed on, I have a cheat sheet here, that's how I'm keeping it straight.
So, okay.
Yeah, that was committed on October 18th of 2006. You have that as number one. What I'm going to tell you is there is a scenario without the California convictions that you could possibly apply subsection D to the
Oh, I
Mojave
see.
County ones because you have three separate convictions in the 58 case.
Wouldn't
And
we
so
need
the-
to send this back to the trial court? I mean, really.
You know,
You're asking a lot of judicial notice. We like to take judicial notice of really easy things.
Oh,
not
I
this.
know. And candidly, the way things were handled on remand, I'm almost afraid to have you do that. But
It'd mess it up even worse.
But the point is that there are three convictions there. Now, the problem with that analysis is that you do have 4 Arizona convictions, but when it comes down to the 58 case, Judge Jansen didn't make any findings as to whether or not they were committed on the same occasion. I want to remind the court he was a trial judge in the 58 case.
But they could have been, under the time frames alleged, they could have been committed on the same date.
Well,
Right? I
that's
just looked at that.
exactly what the problem is because, you see, I asked Mr. James before this hearing, and I want to be very fair to him. You see, he doesn't have access to those transcripts. I do because my office handled it. The attorney who did handle it is now working for the Supreme Court as the staff attorney, but I read those transcripts, and there is a lot of information about how the defendant committed these crimes. When it comes down to the fraudulent schemes, what happened was the defendant lived across the street from the house where all this took place.
But you know what? Besides going outside the record, that's just not something we're going to fix by
Right.
taking judicial notice. So let's talk about a framework for a remand. How would a remand be fashioned? Would it be without prejudice to the court's ability to revisit whether B and C are in play for any or all of the convictions, or what? If we're not going to fix all of this globally on appeal, what's your position as to what should happen on remand?
Yeah, well, B and C certainly can't apply because, well, the only one that it could arguably apply to, is the fraudulent schemes and artifices because the date goes from August 4th of 2006 to December 20th of 2006. The theft was committed on October 18th of 2006. It was the theft of a carpet cleaning machine from an Ace Hardware store. The fraudulent schemes occurred at a residence where the defendant was using someone else's house who lived in California, and he was renting it out or using it himself while the guy didn't know it was being used in that fashion.
And he's convicted of stealing a shampooer?
Yes, he didn't return it.
Not return.
So basically what you have in the fraudulent scheme is it did start before the theft, but it continued after, and that's the only one that conceivably subsection B would apply to. Or B or C would apply to. But with respect to the others, subsection D would be the only game in town. that the court would have to find 2 prior convictions, whether it be one or both of the California ones, or just one of the California ones, or all 4 of the Mojave County ones. So that's the reason why I was going to say yes. Unfortunately, what I did was I looked at the prior brief in the 58 case and saw the defendant had gotten consecutive sentences. He had gotten a consecutive sentence for participating in a criminal street gang from the other 2, and I said, oh, that's kind of interesting. And then I started reading it. Now, I mean...
But because, and correct me if I don't understand this, because the trial court in this case found that it wouldn't differentiate between the dates of the offenses, as far as this appeal goes, we're stuck with that.
Well, what he said was, I don't need to delve into it because I found the requisite numbers. Just counting the 363 count as 1, and then this 58 case is 2. I don't need to parse out 58 into 2, 3, and 4. That's why I wish that he had done so, but the court did exactly the absolute minimum it had to make the findings that it did, and it reimposed the same sentence, and I think that we've put more effort in the case since then than had been done by any of the attorneys previously. I'm trying very hard to strain under the right result, wrong reason here. I do think that the California convictions do qualify as 1 and 2. Then with the Mojave County ones, I mean, the court ultimately, in deeming the 2 Mojave County Superior Court cause matters as the 2 historical prior felony convictions, solves the matter, and that's actually the easiest way for the court to deal with it. If you were to remand it, Judge Downey, I do want to tell you, I was thinking about it. I mean, I'm asking the court to take judicial notice of anything the Superior Court could have taken judicial notice of. Judge Jansen very simply could have taken judicial notice of his minute entry from September 10th of 2010 or September 15th of 2010, the 58 case, and made those findings here in this case. And I'm asking the court to do that in my brief. I was thinking about, well, what should I tell you to do with respect to the alternative situation where you don't consider all of the California convictions, maybe just 1 or none of them, and you rely exclusively on the Mojave County ones. I looked at State versus Kelly, and State versus Kelly was a case where the Arizona Supreme Court sets forth the standard for crimes committed on multiple occasions or on the same occasion. In that case, they did remand to have the trial court decide the issue in the first instance because, you know, that issue wasn't raised. The defendant didn't challenge the convictions. Well, here, the defense attorney, Mr. Brewer, didn't challenge the Mojave County Superior Court convictions as being committed on the separate occasion. So all the Arizona Supreme Court had before it, I think, in the Kelly case was a pre-sentence report. So it remanded. Now, the reason why I bring up judicial notice is that this court did handle the direct appeals in both of them, the antecedent Mojave County Superior Court cases. The 2007-0363 matter, this court had docketed as CR1 And so you do have those transcripts. And when it comes down to the 58 case, that was CR190313. And so the court has all the transcripts. The reason why I bring this up is that when you look at cases other than Kelly, when you look at Shulark, when you look at Perkins, when you look at all the cases that I cited, in those cases, this was under the regime of the Hanna priors, where if the state charged the defendant with 10 prior felony convictions, like in Perkins, the state could then use, even though they're all tried together, some of those convictions as prior felony convictions, and you always had a trial transcript for the Arizona Supreme Court, the Court of Appeals to look at. And so what I'm saying is that you might not even have to remand. You have all the transcripts. You'd be in the same position as the Arizona Supreme Court. Candidly, I don't think anyone wants to do that. That's a lot to ask. The alternative is to order supplemental briefing. Mr. James will need to get those transcripts.
Well, that's just it. The problem, it's not, as you know what the deal, you're not only asking us to search the transcript in another case, but asking us to do it without counsel having the advantage of the transcripts too. And you did offer to provide them, I think impliedly so. But
no, I'd be very happy to. The thing I'd like to say is that, you know, you have actually 2 options with respect to the second alternative thing. I couldn't answer this question, honestly, if I said yes to your first question. I know there's another way. You have 2 choices. You could remand and hope for the best with this cast of characters to get it right. Or you could, you know, have briefing based upon that and that's going to take a lot of judicial resources. But I think the simplest thing the court can do is find the California convictions to be non-historical prior felony convictions. That would be 1 and 2. Then, as as Judge Jansen had found, the 363 prior would be 1, the theft, and then the second one would be the 58 case. It would be the third and fourth. It wouldn't matter that they were committed subsequently. And I think that would handle it. Now, I have 1 minute and 18 seconds. Do I have any additional questions I can answer?
What about Mr. James' argument that the court didn't specifically state what California statute it was relying on when comparing the elements on the taking of vehicle?
Right.
without
Well, the
written
state
consent?
did allege priors, and it did indicate what the
California
what it was.
statute.
And also, when you take a look at the exhibits that were introduced in evidence at the proved prior hearing, the state did introduce the prior felony conviction. It does say 487C for the theft, and the California Vehicle Code 10851. I do believe it appears there, but it also was introduced more specifically in the 58 case, when the state filed its response. Not only that, it was also admitted in evidence at the trial in the 58 case, and the state had indicated, and it's all appended in it's an appendice in my brief, but the state even got the defendant to admit that he had those priors, and it had been admitted. So it's all on the record. And the other thing, too, is that the state doesn't need to plead these statutes or anything. It's something the court can take judicial notice. In State versus Alt, our Arizona Supreme Court took judicial notice of the convictions in Texas and everything else.
And it's just to permit meaningful appellate review, we need to be able to see, what statutes the court was actually comparing. But
I think it's in the record. Thank you very much.
So just to summarize, I'm sorry, you're saying either we should look at the California convictions, discern the statutes, the California code statutes that underlay the convictions, compare the elements to the Arizona crimes, and thereby find 2 non-historical priors, or invite briefing and read the transcripts of the
Prior to
058
cases.
trial.
They're
In
not-
order to
they're not-
find more than one conviction.
Right. You would have to
on the same
find
date.
4 convictions in the Mojave County cases, make the first 2 non-historical because they would be committed subsequent to, and then the third and fourth would be his first and second under subsection D. I mean, it would be the
Yeah.
third or fourth, but the first and second prior felony conviction. I wish our legislature would use terms a little bit more naturally, because it feels like we have wooden tongues here. Thank you very much.
Thank you.
Thank you. First of all, with the state's request to have this court do the trial court's job, I believe that it's more appropriate that the trial court do that. And this, I don't know a whole lot about 363 and the 58 case, other than having looked at some of the sentencing documents as they relate, so I can get the dates as alleged. So I don't know what Judge Jansen may or may not have found. I don't know what the prosecutor may or may not have presented, but I do know that the prosecutor in this case was the same as the prosecutor in the 5-8 case that the state is asking the court to look at, and he didn't. He chose not to present any of whatever he presented in that other case in this case. And by his doing that, it's our position that he failed to meet his burden of proof with respect to any allegation of priors. And again, this is a case where the priors were apparently alleged sometimes significantly. Well, they weren't ever specifically alleged. They just showed up, and apparently Mr. Brewer had some knowledge of them because he makes reference to them in his sentencing memorandum. But going back to the original sentencing from May 13 of 2009, where the trial court made the mistake of sentencing him with 2 historical priors without going through any of the colloquies that were required, we're asking that the court not accept the state's invitation to do what should have been done in the trial court before. With respect to what we're asking the court to do is, if the court does find that 2 California convictions are necessary to make two historical priors. Again, we're asking that the court find that there aren't any California convictions because the record's not clear enough, and the state shouldn't be given the opportunity to go back and prove what they should have done before. In that respect, we're asking the court to find no California convictions. With respect to...
Counsel, so you're taking issue with the state's assertion that if we look in the record, we can identify the California statutes that are involved and compare them?
Well, if this court can look at this record and compare those, yes, I think that the court could, but I think that the court should make its findings based on the record in this case. It appears that this is a case that, you have a defendant that's gone to trial or twice already. He's been convicted of a Class 2 in one case. He's been convicted of 2 Class 2s in a second case. And now he's being, convicted of trafficking in stolen property regarding a washer, a dryer, and something taken from a residence that he used to live at. And the state clearly came into this third case as with a cavalier attitude as to what would happen, and perhaps not really caring. I think his comments in the sentencing hearing show that what his attitude was towards what was going on. He was cavalier about what he said about the California convictions, when they occurred. The state did concede at this sentencing that the 363 and the 58 were committed on the same occasion. So in that respect, the prosecutor of the state should be committed to that concession. And that's what the court found, and the court unfortunately incorrectly applied Thomas in finding that there were 2 historical priors. We're asking that this court remand to the trial court with the instructions that Mr. Montoya should be sentenced with no historical priors, and let the court make the appropriate determination based upon that as to what the appropriate sentence would be. I know at this time he gave him the mitigated term of imprisonment. I don't know if that's what he would do again, because he could potentially use those other offenses for some type of aggravation. Thank you.
Thank you. Thank you both for your presentations. They were actually very helpful. And we will take this matter under advisement and issue a ruling in due course. At this time, we will stand in recess.
No, you did very well. You were very even. I didn't see anything that was
I honestly, here's I don't know, my history. Judge Jansen and I, we started a week ago from Ohio County Attorney's Office.
Oh, really?
And Mr. Skousen has been there since before either one of us were there.
Yeah.
And that was in '92.
Well, he was upset because he thought that I misconstrued Thomas. I called him up and I said, no, that only applies to subsection A. He said, that was my case. I said, I don't care if it was your case. You're wrong in the way it was understood. So yeah, but I mean, it's...
If it goes back to the trial court, I probably will still potentially represent Mr. Montoya, and I may or may not be able to speak to Mr. Skousen and get he's got the conviction. I mean, he's going to get a consecutive sentence. The guy's already doing it for 20 years.
Yeah, he's done for his 9th Circuit cases. Thank you very much. Take good care. Yeah, he's already done for the 9th Circuit for the other cases. But this was you around.
All right.
Easy case. Do you need help with anything?
No, I'm good. Just gonna say